Hello, I'm John Hurd. I've been representing Social Security, Disability, and SSI claimants for over 30 years, and I'm a named partner in Hurd & Smith. Right now I'd like to visit with you about what to do if your case is denied and you're considering filing a new application. Let me first address a related issue. Some people hear that if their claim is denied when they first file it with the Social Security Administration or on reconsideration, one of the first two steps, that what they should do is file a new application and not appeal. And that's a mistake. Filing a new application is not an alternative to appealing. So if you have applied for disability benefits and been denied, appeal and seek reconsideration. If you've been denied on reconsideration by the state agency, the DDS, in your state, then you want to request a hearing before an administrative law judge. That's really where you're going to have possibly your best chance of winning your benefits, because it's the first time you'll be able to explain your case directly to another person rather than just rely on them reading your medical records to make a decision. So now you're at the hearing with a judge, you do your best to win, but you receive a denial in the mail from the administrative law judge. And now the question is, do you just handle that appeal, or do you give up on your appeal and file a new application? Or can you do both? Well, the law was changed some time ago to allow you to do both. So that really is usually the best answer. But it's a little complicated, and I want to touch on some of the points that you may want to consider. First of all, if your case was allowed but only partially allowed, let's say that you feel you were disabled for 3 years and the judge found you were only disabled for 6 months before the hearing, so you're going to lose, if you will, 2.5 years worth of benefits from that, you may want to appeal that partially favorable decision. But bear in mind that if you do that, the Appeals Council can send that case back and they can take away the favorable part of the decision. If you appeal, you're not only appealing the part that you didn't get, you're also having them review the favorable part that you did get, and you could have that taken away. But let's assume that you got an outright denial of your claim by the administrative law judge. An unfavorable decision is what the decision will say. You should appeal that to the Appeals Council. It doesn't cost you anything to do it. Be sure that you do it within the same 60-day deadline as you have on the other appeals. Now, this is where the additional step comes in. You can actually file a new application for benefits even though you're appealing from the denial of your claim by the administrative law judge. And many people do that. We do that for our clients on a regular basis. Often, the benefits will be allowed on the second application, the supplemental, if you will, or secondary application, while the case is still on appeal at the Appeals Council. Now then several things can happen after that. The Appeals Council can decide to deny your case and ignore the fact that you were awarded benefits on your subsequent application. Or they can decide to send your case back for another review. If they do that, then they will look at the fact that you were allowed on your subsequent application, and the Appeals Council may leave that alone and say, let this individual continue to receive his or her benefits, but we want you to consider, Judge, whether you made a mistake on that first denial for that period of time in the past. Or the Appeals Council may say, and unfortunately this happens with some regularity, well, we're going to send the case back because, Judge, we think you didn't touch all the bases you should have touched, you should have considered additional evidence, for example, and also we're going to set aside the subsequent favorable decision, and we're going to combine that subsequent second application with the first application that we're sending back for a new hearing, and we want you, Judge, to have a hearing and consider everything, both applications. Now that, of course, is unfortunate. If you're already receiving monthly benefits and maybe medical benefits, you're going to lose those potentially if the judge denies your case when it comes back on appeal. It's very important also to understand that at least the first time you appeal to the Appeals Council, if your case is sent back, or remanded is the correct term, it will be remanded to the same administrative law judge that denied the case. If you are denied a second time and appeal to the Appeals Council again, and the case is sent back again, it will be sent back to a different administrative law judge. But that first remand, the first new hearing ordered by the Appeals Council, will be to the same administrative law judge that denied you in the first instance. And the theory is that we want the administrative law judges to learn from their mistakes. But in any event, that's something to consider when you appeal to the Appeals Council. So Should you appeal to the appeals council? Generally it's a good idea, but you do run the risk that if you also file a subsequent application, which is certainly also a good idea, and you are allowed on that subsequent application, there's a possibility that the appeals council could take away your benefits at the same time that they send that case back for another hearing. If all of this sounds sort of complicated, well, it's because it is, and it's really probably a good idea to have a representative who's very experienced in these matters if you get to that point and have to make that decision.
If you have a question or comment about this video, please send us an email to webclients@hurdandsmith.com. We also welcome your questions on Social Security disability. Send us an email and we will reply with an answer. We may even answer your question in a video. For a free consultation with disability specialists who can help determine if you are eligible for Social Security disability benefits, call us today toll-free at 1-877-435-3737. To learn more about Social Security disability benefits, visit hurdandsmith.com to download our no-cost disability guidebook.